Good morning.
Good morning, Your Honor.
All right, so good morning. This is the civil calendar for Alexander Harris versus Durand Summers and Southwest Airlines. This is the August 31st, 2022 calendar. Judge Tammy Long Hayward. I'd like to introduce you gentlemen to my new staff attorney, Ms. Camille Heath Fortson, and you all know Ms. Terrell. Mr. Craig.
Yes, Your Honor.
All right. And Mr. Struber? Oh, sorry, Mr. Norris.
Yes, ma'am.
All right, so we're before the court on defendants Southwest Company's motion to dismiss plaintiff's case cause of action with prejudice, and Durand Summers' motion to dismiss plaintiff's cause of action with prejudice, both filed on April 8th of 2022. There was a timely response, and so now we are here to hear the motion. All right, Mr. Norris.
Thank you, Your Honor. And as you said, Your Honor, my name is Dean Norris. I represent Southwest Airlines and Durand Summers, and this is Durand Summers and Southwest Airlines. They filed both motions to dismiss with prejudice based upon 9/11-12b-6, failure to state a claim, and that failure to state a claim motion is based upon Georgia's two dismissal rule. I think I'll point out at the outset, this is based upon Georgia's statute and case law regarding the two dismissal rule. In addition, Your Honor, I just want to remind you, our original motion also had a motion to dismiss the action against Durand Summers, and that's just solely Durand Summers' motion for insufficient service of process, and that's under Georgia statute 9/11-12b-5.
Oh, hold on. I didn't understand that there was a motion to dismiss for failure of service. I thought this was just based on the two dismissal rule.
Well, we had the first motion that we filed, Durand Summers' motion. He goes through that. That's in the motion.
Mr. Norris, when was that motion filed?
April 8, 2022. On page 5, it talks about the law on insufficient service of process, and then it speaks upon page 7, the law on insufficient service of process, and then the argument begins on page 10 through 11 on insufficient service of process, and again, that's on Durand Summers' separate motion to dismiss filed on April 8th.
Judge, I'm sorry. I must have missed that. I am prepared to argue on the 2 dismissal rule, but if the court will give me.
Mr. Craig, I must have missed it too. I'm looking back, trying to find where that motion came in. And I went back in generally Mr. Brazil would send me an email regarding the motions he has. I'm looking at the email from April 11th of 2022. Let's see.
And it was e-filed on April 8, 2022 at 1:28 p.m.
Judge, you want me to send you a copy? Email you?
Yes, Ms. Val.
You at CPU 8?
No, I'm on, I'm looking on my email.
Okay.
I don't understand why I don't have that.
Judge, notwithstanding, if the court will give me, say, 5 days, I can have a response to that part of the defendant's
Well,
motion.
seeing as how I don't have it either, I'll give you 10 days.
Thank you.
And I'm trying to figure out why I don't have it.
And Your Honor, I respect that, but I do just want to make it clear that we filed this on April 8, 2022.
I'm not saying that you didn't file it, but it was it's very unusual for Mr. Brazil to miss anything. And I'm looking back and I don't see it. So it just may not have come to us. They may have sent it to another judge.
Well, and just for clarity purposes, so there's on April 8, 2022, there was 2 motions filed. One's by Southwest.
Okay.
And that covers the 2 dismissal rule. And
Right,
Southwest.
I have that one.
Yes, ma'am. And then there's another one filed by Duran Summers. It's separate, filed on the same date, almost at the exact same time. And that's his motion to dismiss. And it covers the entire 2 dismissal rule argument, but it also covers insufficient service of process. And it's, I mean, it's the second bullet point. I mean, the second point.
I'll have a response within 5 days.
All right, so I'm looking at the Rule 9 side, and it talks about the briefs and where the party cite Joyner versus Lephart or Lephart regarding the 2 dismissal rule. And because of the reversal of the Court of Appeals opinion in the case, the court gave the parties additional time to supplement the brief. However, I did not see anything on there about the failure to serve or failure of service. So we may have just missed that. Judges are fallible.
So are
It
attorneys. So are attorneys, Your Honor.
So we will go forward with the motions on 12B6, and then we'll give you some time to, and me also, to get up to speed on the other motions, and then I'll issue an order, hopefully all at the same time for both.
Thank you, Your Honor.
All right, sorry, Mr. Norris, about that. My apologies, but that missed me and Mr. Brazil.
I understand, Your Honor. Okay, and I would, I guess, for my own, just to cover my tracks, so to speak, I do just want to make it clear, and I know you didn't have it in, weren't prepared on it, Your Honor, but you do have that's filed with the court, though.
I do.
Okay, all right. That's all I just want to make sure about. Okay, and I can address the 2 dismissal rule now, Your Honor, or if...
Sure.
Okay, and so just addressing that today, and I guess we're holding off on the my other part of the argument on behalf of Duran Summers for the insufficient service of process. Today, I'm going to go over the 2 dismissal rule, And is how I'm going to approach that, Your Honor. I'm going to talk about the law that's regarding the two dismissal rule, both the statutory and case law, and then go through the procedural history of the two previous cases that occurred before this case, along with the facts. And then I will apply the procedural history, the facts, to the law as it stands now with the statutes and under the Joyner decision. And then I'm also at the end going to address some of the arguments made by the plaintiff in his supplemental brief and his original response to our motion to dismiss. For clarity purposes, the motion to dismiss under 12b6 for failure to state a claim is identical for both Duran Summers and Southwest. One, I want to say thank you, Your Honor, for allowing us to brief this again based upon the ruling in Joyner v. Lepart in the Georgia Supreme Court. I appreciate you giving us the opportunity to do that. But one thing is we did the original response by the plaintiff. He had mentioned privity as an issue that was needed for the purposes of the two dismissal rule. We actually briefed that in our original response before the rule Nissi order came out, and we talked about the privity existed between the cases. Joyner v. Lepart, the Georgia Supreme Court decision, does not abolish the two dismissal rule. Despite what may be argued by the plaintiff today, the two dismissal rule is still alive and well. It still exists. The statute's not been overruled. Is what did get overruled was the prior precedent only in regards to that two dismissals count regardless of the defendants that were named. That's the only part that Joyner adds to the two dismissal rule. So, and I'm going to go through this in more detail, but just as a general outline, everything about the two dismissal rule remains the same, with exception now there's an additional element that's been added by the Joyner decision that now there has to be a res judicata. The defendant, if he's going to benefit from the two dismissal rule, he has to also prove res judicata exists. Now, there is some overlap between if you prove the two dismissal rule exists and the elements of res judicata. So essentially is what happens in Joyner is that the case was remanded for the opportunity of the parties to show that there was privity between the dismissed parties. Again, we'll go through that in detail, Your Honor. But I just wanted to highlight that for you. Our motion, our original motion in the present supplemental brief that we filed after the rule Nissi order shows that there was already two dismissals of the exact same cause of action prior to the plaintiff filing this present cause of action. We also show in our original motion, along with our supplemental brief, that Southwest is in privity with its employee Duran Summers regarding those two previous actions, those two previous cause of actions, and also with this current action. So since there's privity between Southwest and Summers, and it's the same cause of action in the previous two dismissed cases, then this present cause of action should be dismissed against both Southwest and Summers. And Your Honor, I'm going to show my screen here and we'll look at the statute, because there's an important distinction that is missed by the plaintiff in regards to the federal rule and the Georgia statute that is important for the distinction of what we're arguing here today and some of the arguments made by the plaintiff that I'm going to get to in greater detail slightly later. But if I can figure out how to show my screen here, I'll do so now. Well,
Okay, so generally you go to the bottom of your screen where you see screen share, the little green upward arrow.
okay. Do y'all see it now?
Yeah, you can. So when you click on screen share, let me just tell you what's going to happen.
Okay.
It's going to pull up other things on your computer. So if there's something that's privileged that you don't want to pop up, just close everything. But what it's going to do is allow you to click on whatever document or graphic you want to show. You can choose that one, and then it'll expand and share with the group.
Yes, ma'am. Hopefully you're seeing just the Georgia statute 91141 right now. Is that right?
Right now, I'm just seeing y'all.
Oh, okay. I'm technologically challenged, Your Honor, so you're gonna have to.
Mr. Norris, I just always say, find somebody in their 20s.
Okay, I think I got it now. How about now?
There you go. Perfect.
Okay, so this is Georgia's dismissal of action statute. If you look at the structure of this, Your Honor, and I'm going to come back to this later because of its importance, but 91141, it has a subsection A, voluntary dismissal and effect, and then subsection 1 of A is by the plaintiff by stipulation, and it provides the time period when that can occur and how that can occur. And then subsection 2 is by order of the court. So 3 is where the effect is, and that's where the 2 dismissal rule comes in under 91141A3. And it says a dismissal under this subsection, and as Joyner states, this subsection is referring to subsection A, is without prejudice except the filing of a second notice of dismissal operates as an adjudication upon the merits. So it's what you have when it says this subsection under subsection A is you have 1, that's when it's dismissed by the plaintiff voluntarily, and then 2, when it's dismissed by an order of the court based upon the plaintiff's request for a voluntary dismissal. The effect 3 comes at the bottom of that, and it applies to both of those by the very clear nature of how that statute's drafted. Now, so I just wanted to point that out, and we're going to get to that, or I plan to get to that in more detail and comparing with the federal rule later. Let me see. So the 2 dismissal rule, as I said at the beginning, Joyner only overturned the precedent regarding the broad application of the 2 dismissal rules application to regardless of the defendant's name. The 2 dismissal rule still stands in effect, and that's if a cause of action has been dismissed twice by courts of competent jurisdiction, then that stands as an adjudication on the merits by the statute and the very nature of the law, the exact language, so that a third one cannot be filed. Now, what is a cause of action? This is disputed somewhat in the supplemental brief filed by the plaintiff, but as we cite into our motion, and Crow v. Elder, and that citation is 290 Georgia 686 723 Southeastern 2nd 428 2012. That case is a res judicata case, and it's discussing what is defined as a cause of action in Georgia. And specifically, a cause of action is deemed to be, in quotations, the entire set of facts which give rise to an enforceable claim. The issue is what injury is being claimed, what's the relief being sought, what is the action? Is it a personal injury? Is it a tort? Is it a fraud claim? And Joyner goes through great length to say that despite what the federal rule says about claims, where its application of the 2 dismissal rule in federal court is only to claims, here in Georgia, because of the language of the statute, it applies to causes of action. Now, as stated in Joyner, Joyner added a additional element of res judicata. Our position is that we satisfy that additional element of res judicata based upon procedural history that I'm going to go through, Your Honor. But the important thing about Joyner is the issue that was taken up by the Supreme Court is very specific. And it says it at the very beginning of Joyner, and it says this: did the Court of Appeals err in holding that the 2 dismissal rule applies to the second voluntary dismissal of an action, regardless of the parties named as defendants therein? Well, the Georgia Supreme Court says, yes, the Court of Appeals did err because it doesn't apply to every person, regardless of the defendant's name therein, there has to be a res judicata between the, if you're seeking the benefit of the two dismissal rule, you have to meet the requirements of res judicata in order to benefit. Well, what's the requirements of res judicata? Well, in joiner, fortunately, they go through what the law is on res judicata. And there has to be an identity of cause of action. In other words, there has to be a same cause of action between the two prior cases. And there has to be a previous adjudication on the merits by a court of competent jurisdiction. Well, as explained again in joiner, this element is going to be satisfied by the two dismissal rule. So if there's been two dismissals by courts, that's the previous adjudication that happens. So that's satisfied by the statute. The real issue is examined in joiner is this new element that's been added to the two dismissal rule, and that's is their privity. No longer can any defendant, Joe can't claim a dismissal of John and Bob counts toward him unless Joe is John or Bob, or Joe has privity with John or Bob. That's what joiner is saying. Now, in joiner, this case was, I'll just briefly go through the procedural history of it, only just to give the background for the court. It was a med-mal case where a baby had died. A doctor and some corporations and nurses, they were sued in Fulton County. And then by agreement, the case was transferred to Chatham County. Then later on, the plaintiff decided to add two more parties. And instead of adding them in Chatham County, they filed the two new lawsuits back in Fulton County again. Then there was an agreement amongst the attorneys for the plaintiff and the defendant to say, let's just put all these guys together in Chatham County. We'll keep it in one place. And so the plaintiff's attorney, he dismissed his two actions in Fulton County before they were transferred to Chatham County. And then the defendant, the doctor defendant in the med-mal case, he made a motion to dismiss based upon the two dismissal rule. Well, the Court of Appeals said, regardless of the defendant's name, he gets the benefit of it. Now, under joiner, he wouldn't get the benefit of it unless he can show that he is either the same parties that were filed in the two previous cases in Fulton County, or he's in privity with them. The case was remanded for the doctor to have the opportunity, presumably, to do that, to show that he's in privity with one of those two dismissed cases. The court is very clear in making a distinction that while the federal rule applies to claims because of the plain language of our Georgia statute, it applies to an entire cause of action. So it's broader in that respect. Again, the only thing that joiner adopts is really a privity provision when it adds the elements of res judicata to it. Now, res judicata, I've given the three elements for that, and that's the same cause of action. The parties must be the same party or in privity, and there must be a previous adjudication on it. Res judicata is also defined under our statute 91240. So under 91240, a judgment of a court of competent jurisdiction shall be conclusive between the same parties and their privies as to all matters put in issue or which under the rule of law might have been put in issue in the cause wherein the judgment was rendered until the judgment is reversed or set aside. So the statute, as I understand the case law, it was really a codification of what the common law was, but it cites the res judicata, and it includes those three elements that are cited in joiner, and then also replete in the case law. And that to show res judicata, you have to have same cause of action. You have to show that that same cause of action was previously dismissed on the merits by a court of competent jurisdiction, and that if you're benefit from the dismissal of res judicata or the defense of res judicata, that you have the same cause of action that was previously adjudicated before. So now I should say that those three elements, as I said, and the two dismissal rule covers really two of these elements. You wouldn't get the benefit of the two dismissal rule if you didn't have the same cause of action. That's long been the case law. And then the statute covers an adjudication on the merits. If you have to previous dismissals by a court of competent jurisdiction, that by statute language is an adjudication on the merits. So is what we really need to show for purposes of today is that the privity between the parties. Now, and I also am going to take some time to go through that is the same cause of action in each one of the cases, although I think that that's somewhat conceded, but I don't want to misstate the position of the plaintiff on that. So, Your Honor, if I may go through the procedural history of this cause of action that's ongoing in this present cause of action. We've had 3 lawsuits that were filed. The first one started in Clayton County, and that was filed on April 23rd, 2021. That case by the plaintiff was against Southwest and a John Doe. And that is Exhibit 1 to the attachments that we sent the court reporter today and that we filed with the court. And we filed these to hopefully give some streamline and for reference for the exhibits that we'll be referencing today. But the Exhibit 1 is the complaint that was originally filed in Clayton County. And in that complaint, it alleged that the plaintiff was an employee of Delta and that he was operating the tug at the Atlanta airport on June 19, 2019, when an employee of Southwest negligently drove a tug into his tug, causing him injury. He says that John Doe was an employee of Southwest and that once he's identified, he'll be served. He also alleges that Southwest is vicariously liable because of John Doe's actions were in the course and scope of his employment with John Doe. So that's really the gravamen of the case in Clayton County filed on April 23rd, 2021, that this is a personal injury case, it's a tort case, it's date of injury of June 19th. The injury comes from a tug accident between the plaintiff and this employee of Southwest. That's the bones of the case. Well, procedurally and historically, because this rebuts some of the claims made by the plaintiff that we're going to get to, on May 12, 2021, in Exhibit 3, we emailed the plaintiff and we send them what we have on this accident, which is a work comp report of the plaintiff. And that's Exhibit 3, and that's on May 12, 2021, before our answer is even due. Now, then we respond discovery on June 9, 2021, and that's in Exhibit 10 through 12. In our responses to discovery, we produce an incident report that involves our employee, Duran Summers. Now, again, mind you, the complaint is filed against John Doe on these broad allegations of accident June 19th. So we do our research and we find, well, Duran Summers, one of our employees, was involved in the accident. But our incident report doesn't have the name of the other person. It just has Duran Summers involved in a tug accident, it has the time of his accident, it has the location of his accident. We produce that report to the plaintiff. We also say in our responses, Southwest has a belief that a Southwest employee, Duran Summers, was involved in the accident that is the subject of the complaint. He was a ramp agent and an employee. So we give him the information we know. Now, the issue, Your Honor, and this, I think it's been twisted, but it's what we keep trying to figure out is, does what we know about what happened with Duran Summers match with what the plaintiff can recollect individually on his own? And so our discovery is meant to flesh that out, because the Atlanta airport it's a mid-sized city. Essentially, all the plaintiff has alleged is, it's almost like saying, well, my guy got hit in Macon by a Coca-Cola truck. He didn't tell us where, it just is in Macon. There's a lot of Coca-Cola trucks driving around. How do we know that this Coca-Cola truck was driven by this particular guy? Well, tell us what the driver looks like. Tell us what the truck looked like that he was driving. Tell us what road he was on. So we got to try to match those two incidents. And I'll just tell you, Your Honor, I've been involved in cases with Southwest where there's tug accidents, and there's similar tugs out there. So not only is the Coca-Cola truck, you got to tell me what the driver of the Coca-Cola truck that hit you, what he looked like, where were you specifically in Macon, but also tell us what this truck, there's trucks that look like Coca-Cola trucks. And I guarantee you at the airport, there's tugs that look like Southwest tugs. So we asked those questions in our Exhibit 18 filed to the motion today. We asked specifically, well, tell us a little bit about what you know, plaintiff, about this accident. Give me some details to see if it matches with what we know about Duran Summers. Well, they just respond with, well, based upon what you told me, that it's the same stuff. They don't give us any detail in their responses. If you look at Exhibit 18 and the plaintiff's response to number 9, where we ask, give us the details of the driver that you're saying hit you. Describe his physical characteristics. Well, their response is, well, just look at the work comp injury report, that the one that we gave them. So basically they're saying, we're just going to prove it based upon the responses. Whatever you give us, yeah, that's what happened, instead of giving us an individual recollection of what occurred. Now, a second set of requests for admissions are then propounded on us. And again, we say the same thing. We even try to clarify it as much as we possibly can. That Duran Summers was in an accident on that day. He's an employee of ours, but we can't say it's the same accident because you, plaintiff, won't give these detailed responses that we've asked of, what does this guy look like? What does the guy that hit you look like? There's a lot of there's a lot of defenses that could be available depending on who the driver is. For instance, hypothetically, let's say it wasn't Duran Summers on that hit the plaintiff. There's a lot of Southwest drivers out there. What if someone who's not Duran Summers, let's throw out a name, Bob Jones, working for Southwest. Well, he's not on the clock. He's not working for his time, and he's the one driving a tug who hit the plaintiff. We need to know who it was. Is who hit you, Duran Summers? So give us some details. Certainly the plaintiff would have these details of what this guy looks like, but he doesn't give those. So in our response to the second set of requests for admissions, we try to clarify that. We know Summers was in an accident. Tell us some more details. Subsequent to that, we removed the case on August 26, 2021. Now, on September 28, 2021, in the federal court case, the plaintiff files his initial disclosures. Despite what is claimed apparently in the supplemental brief, that they didn't really know, we didn't give them definitive answers. Well, one, I've already explained why there wasn't a definitive answer, because they wouldn't respond with definitive responses so that we can match the two. But in his initial disclosures in the federal court, and that's Exhibit 37, the plaintiff states Duran Summers, who plaintiff has learned is John Doe. So by September 28, 2021, he definitively believes Duran Summers is his John Doe. Now, he really knows this all the way back in June 9th of 2021. On September 9th, 2021, he files his Cobb County case. This is now a separate case. This is action number 2. That's September 9th, 2021. By that time, it's no doubt that he's determined that he believes John Doe is Duran Summers based upon the discovery responses that we've given. Now, it's important to note, because there's some insinuation in the supplemental brief that because of our responses and the time that he was concerned that he may not have time to add Duran Summers to the Clayton County action that was removed in federal court, that he thought it was best to file against him and dismiss. But now, if you look at that, Your Honors, the timeline involved, on June 9, 2021, we give him that incident report and we give him the information about Duran Summers. He waits until October 21st, 2021, before he files that motion to dismiss his case without prejudice in federal court, or alternatively to add the defendant Duran Summers and remand the case. And that's important, Your Honor. His primary relief that he requested was to dismiss the case without prejudice, not to add Duran Summers. And he says that it's a timing issue, but the fact of the matter is he knew about Duran Summers back in June and waited till October, late October, to file that motion. Now, by this point, Your Honor, he's already filed that Cobb action. That's the second action against Duran Summers. That's filed on September 9th, 2021, and that's Exhibit 26. It's served on October 11th, 2021, a little over a month later, and that's Exhibit 41. It's important to note, and I'm just going to put this on the record, even though this dovetailed into my insufficient service argument, but I am going to put this on the record, Your Honor, if you will allow me, that service on Duran Summers, who's the only defendant named in the Cobb County case, is at 4183 Fortune Point Road, Atlanta, Georgia. Now, in the second action, which is a Cobb County case, the plaintiff alleges that Duran Summers is an employee of Southwest and that Duran Summers hit the plaintiff while driving a tug, both of them driving a tug on June 19, 2019 at 9:50 a.m. He takes that time from our incident report. And that this happened at the Atlanta airport. He makes the same claim of injuries. He makes the same claim against the same person who was John Doe before. Now he says, well, I know it's Duran Summers, so that's who it is. And he also says his allegation is that Summers was in the course and scope of his employment with Southwest. So the gravamen of the second action is the same as the first action. It's a tort.
And Mr.
Yes,
Norris, just to interrupt for a second, Judge Hayward experienced little technical difficulties, so she's rejoining.
Okay. How long has she been gone for?
Less than a minute.
Okay.
Sorry, Mr. Norris, I rolled over my cord and
Oh,
everything
no,
went blank.
that's no problem.
Okay, so we were at the point where they dismissed the removal in federal court, and it was dismissal or add. They chose dismissal, and then this was that was before the I'm sorry, that was after the Cobb County action had been filed. Is that correct?
Correct. Yes.
Okay.
Yes, Your Honor.
All right.
And if I restate something and you just want to say, oh, okay, I got that. That's fine, Your Honor. So I just want to make sure that I have covered what maybe you missed. And I note in that motion that he files in federal court that his primary relief was to request a dismissal, and his alternative relief was to add Summers. But of course, by that time, he had known since June, so for 4 months, that of the existence of Duran Summers. Now, to the Cobb County case, and this is the second action filed on September 9, 2021, that's Exhibit 26, and that was served, and that's just against Duran Summers. That was served on October 11, 2021. That's Exhibit 41. And one point I made, Your Honor, is that while this detail is really to point out to serve the purpose of my motion for insufficient service, I'm just going to get it on the record now very quickly. That service on Duran Summers occurred at 4183 Fortune Point Road, Atlanta, Georgia. And there was no objection to service in the Cobb County case filed. So The gravamen of the Cobb County case is the exact same as what it was in the Clayton County case. Action number 1. The plaintiff in the Cobb County case is alleging that he was injured in a tug accident that occurred on June 19, 2019. And says it happened at 9:50 a.m. Well, I'm pretty sure that time was just taken out of the incident report that we produced earlier. And he claims that he sustained injuries as a result, he being the plaintiff, sustained injuries as a result of that tug accident. He also says that Duran Summers is the guy who was John Doe earlier, and that this guy was Duran Summers was in the course and scope of his employment with Southwest. So as what we have here is the gravamen of the complaints are the exact same. It's a personal injury, tort action for the same injuries that he was hit in a tug accident on the same day at the same basic location alleged in each time, the Atlanta airport. And so in the Cobb case, on November 23rd, 2021, Exhibit 53, Duran Summers answers discovery. And again, this goes to the point of every time that there's been discovery propounded, we've said exactly what we know about it, but we're trying to figure out what the plaintiff says about the accident to see if these two match, or is he involved in another accident with an employee somewhere else, working for another company, or another Southwest employee possibly, who the defense may exist of was it in the course and scope of his employment. So we say in response to the request for admission number 5, Summers says he was in an accident on June 19, 2019 with a person at the airport, and we even go through and say, but because the plaintiff won't give details about this, we can't say it's the same accident. So now we're in the Cobb case, and we're just going to drive to the hoop, so to speak, as much as we can and ask as much detail as we can about this accident. So we propound discovery to the plaintiff. And this is Exhibit 58, interrogatory number 2 and 3 and 4. We asked, plaintiff, tell us about what the length of the guy's hair. What was the color of the guy's hair? What does the eyes look like? What was the skin color? How tall was he? Was he fat, short? We go through voluminous amounts. There was number 3 in that interrogatory. We asked, what was he wearing? Did he have any jewelry? Did he have any tattoos? Did he have any physical descriptions? And then in our interrogatory number 4, we said, what did the tug look like? What was the markings? What was the color? Now, and this is all to flesh out, does what you're claiming match with what we know? So there's no obfuscation of our duty in discovery. We're just trying to make sure your details match what we know about it. And we've given you all the stuff that we can about it. And it's what's been given back to us as a response by the plaintiff is, yeah, what you said, whatever you said. So that's why we ask those discovery questions is give some details about this guy that you said he did. Well, the plaintiff doesn't respond to that discovery. This is again in the Cobb County case. So then after the due date is already passed, February 17, 2022, for the plaintiff to respond, and this is Exhibit 61, the plaintiff's office asked, can you give us an extension for this discovery? We propounded a request for admissions and interrogatories and production. And we respond, and it's in the email that we've attached to Exhibit 61, saying, look, we've been asking you to give us information. We've been asking you to give us a settlement demand. We've been asking you to execute some releases for some documents on to get workers' comp records, and you haven't done any of this. And this case has been going on since for over a year now. So no, we're not going to give you an extension. Well, that same day, February 17, 2022, the plaintiff dismisses the case in Cobb County. So he didn't answer our discovery. Once we said we weren't going to give us an extension, then he dismisses the case in Cobb County. That's the second dismissal. Meanwhile, the plaintiff in his supplemental brief claims that we've acted in bad faith in discovery. I just want to point out those facts, and I think that I'm going to conclude on that point, but I just wanted to get those facts in on the procedural history. Now, how does the law apply to these facts in this procedural history? Well, this case certainly satisfies the two dismissal rule. Was what we have here is the same cause of action. And again, the case law is the same set of operable facts, injury, and theory of recovery. In the Clayton County case that was originally filed, and in the Cobb County case, we have all those things. It's the same incident, it's the same facts being pled, and it's the same injury, and it's the same theory of recovery. It's the personal injury tort claim. Now, those are all the exact same that we have in front of the court now, Your Honor. It's a personal injury claim, it's a tort claim, it's on for the same date, it's at the Atlanta airport, it's against Duran Summers and Southwest. The first one again was against Southwest and John Doe, and the second one was against Duran Summers. Now, the plaintiff says in a supplemental brief on page 4, the fact that both actions involve the same causes of action is of no import in the analysis of whether or not the two dismissal rule applies. And he cites the Joyner at 8, but that's dead wrong. It doesn't say that in Joyner. The cause of action is still an element that is a necessity in this. And we have the same cause of action throughout all 3 cases, Your Honor, the 2 that were previously dismissed. Now, of course, on the two dismissal rule, we have the 2 courts of competent jurisdiction. I don't think the plaintiff argues against that, and that the Northern District of Georgia, where the first dismissal was filed, and the Cobb County courts are both courts of competent jurisdiction. Once that second, and of course by statute under 91141A3, once that second dismissal was filed, that operated as an adjudication on the merits. So the elements of res judicata are satisfied for the 2 dismissal rule under Joyner to apply to this case. And here's why. And here's the elements again, Your Honor. It has to be the same cause of action, and if you're going to benefit from it, and there has to be a prior adjudication on the merits in the same court that you're in privity. And I think I've covered the same cause of action. They're identical and the same. The 2 courts of competent jurisdiction, again, I don't think that there's any dispute on that. And the statute supplies that it's an adjudication on the merits to satisfy res judicata. Now, I think the issue that's debated is the 2 things. Was there a voluntary dismissal and the privity? I'm going to cover the privity first. Southwest is in privity with Duran Summers. Southwest is Duran Summers' employer. The gravamen of the pleadings against Southwest are that they're vicariously liable based upon the actions of Duran Summers. If Duran Summers' employee was not in an accident, Southwest wouldn't be involved in this case. So if we cite to the case Gilmer v. Porterfield, 233 Georgia 671 at 674, and then 212 Southeast 2nd 842. And this really goes back to law school, Your Honor, that we all learned a master's is in privity with his employee, especially when the claim is a vicarious one. And that really is a very logical conclusion to make. The entirety of the gravamen of the case against Southwest is based upon what its employee allegedly did in the course and scope of his employment. So count the dismissals, and I'm going to go through one and show the error of plaintiff's argument regarding privity and then also the voluntary dismissal, Your Honor. That first case in Clayton County, that counts as a dismissal. The plaintiff is arguing that that does not count, and he cites to quite a bit of federal case law, but we're in Georgia. Georgia law applies. The Georgia statute applies. This motion is under Georgia statute, not under the federal rule. So that first case, and I just want to hit on it just so I don't miss it. It has the same set of operative facts in the first case as it does in the second and third case. What mainly the plaintiff is arguing is that dismissal was at his request, but it was by order of the court. And I think that's really if we were in federal court, Your Honor, he'd be 100% right. Because the federal case law says, even though the plaintiff moves for the dismissal or asks the court to dismiss it, if the court actually puts the order in, then that doesn't count under the federal to dismissal rule. Well, that's not how it is in Georgia, because it's two different statutes. The structure is entirely different. I'm going to place this up, Your Honor, would just to. So again, this is our statute. This is the Georgia statute, and this is what we've moved under for dismissal. The effect is down here at the bottom, section 3, and it covers this entire subsection. It says a dismissal under this subsection is without prejudice except that the filing of a second notice of dismissal operates as an adjudication upon the merits. So subsection 3 applies to subsection 2, which is when the plaintiff asks for dismissal and the court orders it, and subsection 1, when the plaintiff does it by stipulation. Now, how's that distinct from the federal rule? And I'll put the federal rule up here. Well, I know you told me earlier, Your Honor, but I'm not. Oh, there it is.
Yeah, you got to hit the green arrow.
Yeah, sure. There we go. Okay. Okay. So this is are you able to see the federal
Yes,
rule?
I have it. We see it.
Okay. So this has an entirely different structure. The voluntary dismissal subsection A has subsection 1 by the plaintiff. It has a subsection A and a B, and the to dismissal rule in the federal rule is here under subsection B, and it applies only to the plaintiff. The effect, unless the notice of stipulation states otherwise, the dismissal is without prejudice, but the plaintiff previously dismissed any federal or state court action based upon or including the same claim. That's one distinction between the two statutes. A notice of dismissal operates as an adjudication on the merits. And down here is the subsection 2 is where if the plaintiff asks the court for an order. So it's a completely different statute in the sense that the effect is applied only to subsection A in the federal, while it's not the way in the Georgia, under the Georgia statute. Now, this isn't my own design. I wish I was smart enough to come up with read statutes this carefully, Your Honor, but the plaintiff cites to a case that lays all this out. And it's talking about the federal statute, why you interpret the federal statute the way you do. Plaintiff cites to ASX Investment Corp v. Newton. That's 183 Federal 3rd 1265 at 1268. And that's 11th Circuit opinion in 1999. In that case, the court makes, the court makes it clear in its reasoning of why and this is what the plaintiff is arguing, of why a court-ordered dismissal at the plaintiff's request does not count under the federal rule. And it goes out to say of just what I laid out in those subsections. And the to dismissal rule, and I'll just read from that case, the to dismissal rule does not state the specific means by which the first dismissal must have been obtained to implicate the rule. It does, however, state the rule is implicated when a plaintiff has once dismissed. And again, this case is talking about Rule 41A from the federal rules, in which the to dismissal rule appears, provides for dismissal by a plaintiff without court order by the filing of a timely notice of dismissal or a stipulation of dismissal signed by all parties. Dismissal on plaintiff's motion and by order of court, on the other hand, is provided for in Rule 41A2. And this is the important part. Rule 41A1 and Rule 41A2 each ends with a sentence explaining the effect of dismissal obtained under their respective provisions. So the federal rule is completely different in that regard to how Georgia, because the effect applies to both court-ordered dismissals and plaintiff dismissals by stipulation. The plaintiff also cites to a case Crawford v. Kingston in his argument, and that is a Georgia case, Your Honor. But again, it's inapplicable for two reasons to this case. One, in Crawford, this Georgia case, they cite to Reese v. Frazier. Reese v. Frazier is a case that predates the statute that we have today. So the Crawford decision relies upon a case law, Reese v. Frazier, that predates the statute that we have. In fact, it goes back to the statute, and Joyner actually talks about the history of the dismissal rule, where in 1966 a statute was passed. It wasn't changed until 1985. Well, Reese v. Frazier is a 1981 case, and it's entirely different in the sense that the structure of it, and I can place that. Before the court. This is, and I took this from Georgia Law's 1966 session, section 41, the dismissal of actions. And this was the statute that was applicable at the time Reese v. Frazier was decided. As you see, Your Honor, it has a completely different structure. It also invokes the same claim, which Joyner points out that these are all old. This is under a previous version of the statute. So this is not applied to the way we have the statute now. Now also, and I mentioned this about Crawford, there was two reasons. One, Crawford relies on outdated case law that is not coincide with the statute that we have today. The other reason, if you look at this case, and we cite this, Stokes v. Hill, and this is 325 Georgia App 256, this 2013 case. And this case has to do with the renewal of a case and the claims of the relationship between the three, but Crawford is discussed. Again, Crawford is the case that the plaintiff relies on a supplemental brief in part. And it notes that the distinction between the present and Stokes, they end up saying, well, no, the previous two count, so there's a commonality between them. And it notes why Crawford was distinct. And the reason why Crawford was distinct, according to Stokes v. Hill and the Court of Appeals, was that that the second case didn't count for the two dismissals because of the complaint was never served. And they make the second action, I believe, is how they refer to it. The second action was never served, so that doesn't count as one of the two previous dismissals for the purposes of their analysis. And that's Stokes v. Hill, 325 Georgia App 256, 2013. Now, of course, in our case, we do have service in the second action. We have service in the first action and in the second action. Now, also still remaining on the first action in Clayton County, that action's filed against John Doe. Now, one of the things that we argue is that action against John Doe, where it was identified in discovery very clearly who Duran Summers was, and in fact, the plaintiff used that information for the purposes of not only filing his motion in federal court, but also for filing the separate Cobb County action about Duran Summers. And who's identified later on, we say that because of that John Doe dismissal of the first case in Clayton County, that's one dismissal of Duran Summers. And that's supported by case law, Your Honor. The plaintiff has asked that law to be set aside for the purposes of today or purposes of argument as I understood it. But the case is Milburn versus Nationwide, and that's 228 Georgia App 398, and then 491 Southeast 2nd 848. That's a 1997 decision. And in that, the court says that when an unknown person is identified, when a John Doe is identified during discovery, and then later he's identified in a subsequent action, that the John Doe and the later identified person are identical. Now, that case is dealing with the renewal statute, and the argument that was being made in that case is that the statute of limitations have ran. The defendant would say the statute of limitations had run because the John Doe shouldn't count when he identified the specific person. And the court says, nope, he filed against John Doe the first time, and then he renewed his action against this person. Well, this person was identified in the first action, so this counts. John Doe is that guy, and we know it's that guy. So whenever this situation occurs, they're the same people. And that's what we have here. John Doe, who was identified in the first cause of action filed in Clayton County, he's identified as Duran, Summers, and Discovery. The plaintiff acts on that understanding. He files his motion to dismiss so that he could add Duran, Summers, and he files a second action against Cobb County against Duran, Summers. Now, examining the second case in Cobb County and how that impacts the dismissal of Duran, Summers in this case counts, and this case being the Cobb County case, counts as the second dismissal. It's the second dismissal of Summers, as we said in our John Doe argument, but then also it's a second dismissal and it counts for Southwest because Southwest is in privity with Summers. As stated in Joyner, the two dismissal rule and the doctrine of res judicata is applied. These parties are in privity. Southwest is in privity with Summers. We have the same set of operable facts. We have the same injury. We have the same allegations of negligence. Southwest is only liable because of supposedly or allegedly its employees' actions. They're vicariously liable. They wouldn't be involved in this case if it wasn't for their allegations that it was their employee who did it. As we stated in Gilmer, a master is in privity with his employee when the case or the claim, the theory of relief is based upon vicarious liability. And that's I can cite a case of that, Gilmer v. Porterfield, 233 Georgia 671, 212 Southeast 2nd 842 1975 case. But I think that's a fairly basic element of the law that we all know. Now, if you count the dismissals, so if we keep score here, Your Honor, we have two dismissals for Southwest. The first one was a direct dismissal of Southwest, and because Southwest is in privy with Summers, the second case in Cobb County is a dismissal of Southwest. Remember that the law of res judicata is you have to be the same party or in privy with the party that's dismissed. Southwest is in privy with Duran, Summers. And then what we also have, Your Honor, is we have two dismissals of Duran, Summers. Duran, Summers, he's the John Doe. He was just identified in discovery, and he's later filed again. So he is the John Doe in the first case, and he is obviously the person who's named in the Cobb County case. So there's two dismissals there. But even if you don't accept the John Doe argument, we still have two dismissals, so the two dismissal rule would still apply. Joyner hasn't changed it. 1 + 1 = 2. And that's what we have here. We have one dismissal of the same cause cause of action and another dismissal of the same cause of action. And the two are in privity with each other. Southwest particularly is in privity with its employee, Duran Summers. Now, I just want to finish up with addressing the bad faith claims against us. And the plaintiff says that we being the defendant, shouldn't benefit from our lack of candor in discovery and for bad faith. And I want to address that point blank in the sense and show evidence that's quite to the contrary, that we're not here because of any gamemanship by the defendants. Quite the contrary, is the plaintiff's refusal, as I highlighted earlier, to give definitive answers, which caused this predicament, and the own choices that he made as far as when to file a dismissal. The first, the defendants have done everything to expedite and move this case to a quick resolution. And that's part of the purposes of the exhibits that we filed, is to rebut this claim of bad faith on our part and gameplay. We attached our motion today, Exhibit 8. On May 26th, is right near after the service of the first complaint, we asked for a settlement demand. We tried to engage in settlement negotiations. On July 6, 2021, we attached Exhibit 15. We again asked, can you give us some sort of settlement demand? Let's get these settlements.
Judge, what does that have to do with anything?
This is to rebut the claim of bad faith on our part, in the sense that we haven't been, that we have engaged in gamemanship. Now, there's no preclusion.
Okay, so Mr. Norris, I would assume that that was my understanding of the bad faith claim, and maybe I'm wrong. I would assume that that was that you all weren't forthcoming in discovery, such that they had difficulty identifying who the John Doe was. I didn't get that it was an issue of whether you were willing to engage in settlement talks. But I'm not sure that either that is going to make a big difference for me.
Well, Your Honor, I think the narrative of these, as I go through them, and I guess to the extent that they don't persuade you, I can point out.
I'm just trying to understand the bad faith argument. I don't want to belabor the settlement talks part of it, because that essentially is not something I should consider generally.
Okay, and I'm not giving specific numbers, Your Honor. I was just that we're engaged, I guess, to the point that we're that there's been a narrative painted that we're reluctantly engaged and that we're just behind the curtains playing games. I think that the narrative that from the exhibits showed exactly the opposite, Your Honor.
Okay.
And Your Honor, if I can, when that issue arrives, when there's an exhibit that speaks to negotiations, I can make that as an offer of proof, Your Honor, if you prefer me to do that.
That's fine. Let's do that at that time.
Okay. And then moving on to July 6th, Exhibit 15, we again asked for some settlement discussions. But July 13th, instead, the plaintiff propounds a second set of requests for admissions. Now, if you go back again to the context, the issue that the plaintiff seems to think that we're acting in bad faith is we're trying to match what we know happened and what we've already told the plaintiff we know happens with what he knows, and he won't give us that information. So then on July 30th, 2021, Exhibit 18, the plaintiff hasn't responded to our specific discovery request to identify the driver, but he just repeats the same information that we've already given him. September 22nd, 2021, Exhibit 30, the plaintiff tells us he's going to execute releases for us, which we still don't have. And Exhibit 36, September 28th, we tell the plaintiff, you're a day late with your initial disclosures in the federal court. We reach out like, these were due yesterday, you're going to file these? And then Exhibit 51, November 18th, we ask again for some settlement discussions. November 23rd, 2021, Exhibit 53. That's, and we've talked about this already in the Cobb case. Durand Summers, he admits that he was in an accident at the airport, and that he was in an accident with a person on a tug. But if the plaintiff would just give me some details, we can see if we got the same two things going on. And that's pretty clear in our response. Exhibit 55, again, it's an email exchange. The plaintiff says he's going to get us a settlement demand. And then January 10th, 2022, we propound that discovery that we talked about, and those are Exhibit 57, 58, 59, where we're saying, look, we're telling you we know Durand Summers was in this accident at the Atlanta airport. Tell us something so that you can give some sort of independent recollection of this accident so that what you're saying matches what we know. But as I said earlier, they don't respond to that, but then they ask for an extension on February 17th, 2022, and that's Exhibit 61. And we respond, we're not going to give the extension. We've gone through this, and that's why this narrative is important. We've gone through all this. We've asked for everything here, but we're not giving you an extension. And on that same date, they dismissed the case. Now, that dismissal has nothing to do with our machinations, it seems like it's suggested by the plaintiff. So that's why that narrative was important, is that there's no bad faith. In fact, we're above the board and we're as full disclosure as we could possibly be. We just need some help from the plaintiff to see what we're talking about here. Now, I'll just conclude that the two dismissal rule applies here. The statute has not been changed. It's only been added to, the res judicata elements being added to. And this is not federal court. This is not the federal statute. Georgia rule is different from the federal rule in a very meaningful way. And that's the effect. That's where the two dismissal rule is applied. And the two dismissal rule applies to whether the plaintiff files a stipulation, a notice of dismissal, or whether the court orders the dismissal based upon the plaintiff's request. The Georgia rule is very clear on that. That's how they order. And even the cases cited by the plaintiff, when they make the distinction from the federal rule, they note how the federal rule operates, why they interpret in the federal rule the way they do. Well, that's not what we have in the Georgia rule. We have the same cause of action in all three of these cases, the same injury, same theory of relief. And we have a party that either the same party or in privy with the party. The same party being Southwest in the first case. Southwest is in privy with Summers, the second case, and Southwest is named here. So the two dismissal rule applies. Joiner doesn't change that for the purposes of this case. Now, if there was no privity between Southwest and Durand Summers, it would be a different story, but there certainly is. And I'll believe that covers my argument, Your Honor. Thank you.
Thank you. Mr. Craig?
Judge, Your Honor, thank you. I think I've laid out the plaintiff's arguments, Your Honor, in our brief. So I'm going to be brief in my argument, hopefully. The defendants in their brief state that they agree that Georgia's two dismissal rule is found at OCGA 91141A3. The defendants state in their brief that in Joiner, the Georgia Supreme Court adopted a rule in accord with federal court jurisprudence interpreting the federal court's two dismissal rule. In Joiner, the court looked to federal law to interpret the two dismissal rule. Plaintiff contends that the two dismissal rule is inapplicable in this case because, based upon the procedural history, plaintiff has not dismissed the same action twice. Again, the Joiner decision states that Georgia courts look to guidance from the federal rules of civil procedure and federal jurisprudence in order to ascertain the meaning and effect of OCGA 9-1141A3. So very simply, Your Honor, plaintiff filed the original lawsuit in Clayton State Court against Southwest and John Doe, plaintiff not knowing the identity of the Southwest tug driver. Discovery ensued. I guess there's a difference as to what's total candor. This time, Southwest cannot state with certainty the name of the person involved in the driver, but based upon the incomplete investigation, Southwest has a belief that Duran Summers was involved in the accident. We sent requests for admissions. Southwest cannot state that Duran Summers was involved in the accident that is the subject of this lawsuit. Well, the Clayton State case was removed by the defendant to the Northern District. There was uncertainty whether Duran Summers was the driver of the tug in question, and statute of limitations was approaching, so plaintiff filed the separate action against Mr. Summers in Cobb State Court. Plaintiff then filed a motion with the federal court asking that the case be either voluntarily dismissed without prejudice pursuant to Federal Rule 41A2, not A3, so that plaintiff could refile his complaint against both Southwest and Summers and litigate against the two defendants in one action. Or alternatively, if the court would allow the addition of Summers as an additional defendant in the federal case, plaintiff would then dismiss the Cobb County case, which would, and then add Summers to the federal case. The federal district court judge agreed that plaintiff's request to litigate his claims against Southwest and Summers in one action did not appear to prejudice any party, that it would promote the interest of judicial economy, that it would not deprive substantial right to the defendant, found that plaintiff had not acted in bad faith, was not acting in bad faith, and the court granted plaintiff's motion to dismiss his complaint without prejudice under Federal Rule Civil Procedure 41A2. Thereafter, plaintiff dismissed without prejudice his case against Summers in Cobb State Court, and then plaintiff filed the current action, which is pending here today. So in our brief, we have cited, Your Honor, both Georgia law and federal law, which we believe is controlling to this case. Again, defendants claim that the dismissal of the federal action counted as a voluntary dismissal under the two dismissal rule, and we contend that that is incorrect. So we've cited the case, Your Honor, a Georgia case, Crawford versus Kingston, which is at 316 Georgia Appeal 313. It's a 2012 case. It's not out of date. And in that case, the plaintiff filed his first complaint in Cherokee County State Court. He voluntarily dismissed the case. Plaintiff then found that the defendant had moved to Florida and filed same case in the Northern District Court. But after discovery, it turned out that the defendant was in Georgia, and the plaintiff in that case moved the district court, federal court, to dismiss the case without prejudice. which the court did. Then the plaintiff, Crawford, refiled the case in Cherokee County. The defendant moved to dismiss the renewal action on the ground that the federal dismissal was voluntary and acted as a dismissal under 911-41A3 and as an adjudication on the merits. The plaintiff, Crawford, argued that the federal dismissal was not voluntary. Court of Appeals agreed. Court of Appeals made clear that the federal dismissal was not voluntary because under Georgia law, only voluntary dismissals filed by a plaintiff are to be counted for purposes of 911-41. Crawford Court then went on to further state the dismissal itself was by an order of the federal court. As such, that dismissal was involuntary under OCGA 911-41A2 rather than voluntary under A1 and thus could not operate as an adjudication on the merits under Section A3. The court went on further to state that when a plaintiff moves to dismiss an action in federal court by order of court, the 11th Circuit has held that the actual dismissal is by the court and therefore does not implicate the Federal Rule of Civil Procedure 41A1 to dismissal rule. So, federal case, ASX investment. There's no basis for reading the two dismissal rule to apply where the first dismissal is achieved by motion and order of the court. Section A3 of the statute has nothing to do with involuntary dismissals. This and that same point was reiterated in a case, Troop versus Chambers, where we've given this citation. Another case, Cunningham versus Whitener, this 11th Circuit case. There's no dismissal rule set out in Rule 41A2. We see no basis for reading the two dismissal rule to apply where the first dismissal is achieved by motion and order of the court. So again, the current action, our case here is analogous to Crawford. A federal plaintiff moved to dismiss their own action, just as the plaintiff here. The district court granted its order in Crawford, dismissing plaintiff's complaint without prejudice, allowing in order to refile in state court, recognizing there would no longer be subject matter jurisdiction if that defendant were added as a defendant, which is the same in our case. And again, the Court of Appeal, when the plaintiff refiled in Cherokee State Court, the Court of Appeals agreed that that was not the federal court dismissal was not a dismissal that counted toward the two dismissal rule. So the federal rule of civil procedure 41A2 is applicable here. And under that, the two dismissal of rule of Federal Rule of Civil Procedure 41A1 is inappropriate. And we contend, Your Honor, that the two dismissal rule has not been triggered as there's only been one voluntary dismissal in this case, and that is the dismissal of the Cobb State Court action filed against Mr. Summers. In the Cobb County action, just to be clear, only Mr. Summers was named as a defendant, not Southwest. And the defendants admit that the elements for Georgia's two dismissal rule must be met, and the facts and procedural history must also satisfy the test for the application of the doctrine of res judicata. Your Honor, when looking at the facts and procedural history here, and in particular, the order from the district court, which we attached as an exhibit, it's clear that there's only been one voluntary dismissal in this case for the purposes of the two dismissal rule. Your Honor, we've also put forth in our brief that the plaintiff should not be penalized because of Southwest's failure to provide information and just simply admit that Deron Summers was the driver. And we have a argument about the John Doe, the status of John Doe dismissals in Georgia, but I'll just reference those arguments in our brief, Your Honor. But in summary, we contend that joiner is applicable to the extent that the Georgia Supreme Court said that they are looking to the federal court for interpretation of OCGA 91141 and FRCP 41. So there's only been one dismissal. We ask that the defendant's motion be denied. And Your Honor, we will submit our supplemental brief on the service issue. I thank you for your time.
Mr. Craig, I found the motion for service. It was filed on April 8th, Mr. Norris. It's real quick, Mr. Craig, so you probably won't need the 10 days, but I'll give them to you. So once you all get that in, then we'll try and do the response to both the order for both motions at the same time.
Thank you, Your Honor.
Anything else at this time? So I got to decide on new law, a new case, whether I think it should be interpreted in conjunction with the federal statute or whether it stands on its own to interpret the cases here in Georgia. Okay, thank y'all.
Your Honor.
Judge, if you have a great law clerk, it'll be easy.
I do. You know, Michael, my previous staff attorney went to work for the Supreme Court. So I take a little, you know, a little bit of pride in that he was good enough to go on above. And I got a call from T. Barnes, who said she was calling to tell me they were going to hire away my staff attorney. I was like, okay, if anybody can give him the second best job he's ever had, I'll let the Supreme Court of Georgia do it. But I now have a new law clerk who's going to be just as good as Mr. Brazil and might surprise me, and he'd be even better. So, you know, I'm looking forward to what she can do, and this is her first week, so we're going to get it out.
First week.
Yeah, congratulations.
This is her first week, not kidding. This is her first week and her first civil motion.
Welcome.
Congrats.
Your Honor, is there any, if I understand, I appreciate I've taken a lot of your time. Is there any chance I can reply to that response very quickly?
Sure.
And I can do it in less than 10 minutes for sure, Your Honor.
Okay.
5. Your Honor, just very quickly in Crawford, that the plaintiff is relying on, I hit on this, but I just want to make sure it's clear that the court is the plaintiff in the Crawford case is asking for a dismissal, and that's a federal, so that in the federal case that was happening in that case, the federal court had decided it wasn't going to have jurisdiction over that case. That's not what we have here. So in Crawford, the second action, the court had decided that it wasn't going to have jurisdiction, and the plaintiff agreed. So it's different in that case than what we have here, in the sense that, as pointed out in the case that I cited to, Stokes v. Hill, there was not subject matter jurisdiction in the second case in Crawford. We have, the complaint was served in our second action. That's quite a big distinction. The plaintiff had mentioned in Crawford that I said that Crawford was outdated. If I said that, I said that incorrectly. What I thought I said, and at least meant to say, was that Crawford relies on a decision, which is Reese v. Frazier, they cite to, and that's a 1981 case, and that Reese v. Frazier is outdated because that's a previous iteration of the statute. So I just wanted to clarify that.
Well, I have that in my notes.
Okay.
Reese was the one that you said was outdated because it predated the statute.
Okay. Yes, I thought I did. And then they mentioned the Troop case, or plaintiff mentions the Troop case in his response that he relies upon. The Troop case is a completely different case, in the sense that in the Troop case, there's an obvious distinction and that that is an actual involuntary dismissal that happens by the court. That's not what we're talking about. The federal court had dismissed the second action because it dismissed its federal court claims and it refused to exercise supplemental jurisdiction over state law claims. That was an involuntary dismissal. That's why that second dismissal didn't count. That's a very obvious distinction. And then one thing I wanted to address, and just very quickly, because I didn't, is that it was pointed out that in the federal case of our federal case, that's the first action of our present case, that we had filed as part of our response to their motion to remove, that we said that there was bad faith involved, and that's why it shouldn't be remanded or shouldn't be allowed to have a dismissal. The plaintiff points out that that was an error, and quite frankly, he was right. And rather than sit on our laurels, I don't think you see this very often. We did something that I think as soon as they pointed out in the response that we sent this email about letting them know about we were going to file against Summers, the very next day, we looked for that email. Once we found it, we filed with the federal court a notice of correction saying, that's right, he's right, we're wrong. When we found it, he was right. So we did that the very next day. We didn't try to hide something. We were mistaken. And then as soon as we saw we were mistaken based on the response, we let the court know we messed that up. I just want to point out two things. Again, this is not some sort of, the plaintiff has not reached this point because of, to the extent that they argue they shouldn't be dismissed because of things that we did. It's things that they did. The federal case, they asked for the primary relief of a dismissal. They could have asked for the primary relief of adding Summers and then a remand. They didn't do that. They chose a dismissal. In the Cobb County case, they could have added Southwest. They could have tried to add Southwest as a defendant to the Cobb County case. They chose not to do that either, Your Honor. So their own decisions is what led us to that predicament. I think I was under my 5 minutes, so thank you, Your Honor.
Judge, I've got one quick. First, we did ask the federal court, we asked the federal judge to do one of two things. Allow the dismissal of the case without prejudice, or two, let us add Mr. Summers, and then once he would add it, that would destroy the diversity and remand the case back to Clayton State. The federal judge decided the former. And secondly, we couldn't have added Southwest to the Cobb State case because Southwest was already defendant in the pending federal case. Thank you, Your Honor.
And can I respond to that very quickly, Your Honor?
Let's put it this way. Mr. Craig has been before me and he knows I got a patience threshold. So because I can read the documents myself and follow along, I'll get it right. I promise you. I'm better visually than I am auditorily. So if I see it, I can catch it much better than if you tell it to me.
Judge, thank you for your time today.
Thank
All
you,
right,
Your Honor.
did you all settle up with Mr. Baker or get his information?
I'll get their information, Your Honor, and get them something out.
All right.
Get a bill, I should say.
Okay.
Gentlemen, just let me know if you want this transcribed. We can get that done for you.
Mr. Baker, do you have my assistant's contact information?
I
do I have
believe so.
yours?
Is she the one that emailed the exhibits this morning?
Correct. Yes, sir.
Yes, sir. I've got her contact information.
Okay.
Mr. Becker, Mr. Becker, you want my email?
That would be great, Mr. Craig.
Yeah, it's blair@woodcraig.com. And I do not need it transcribed at this time.
That's fast. That's fantastic news. How about you, Mr. North? Any thoughts you might want this transcribed?
I was trying to just be quiet. I didn't want to exhaust anybody else's patience. So yes, and my assistant, does she have your email? I know you have hers, but does she have yours?
She sent it to me this morning, I believe.
Okay.
Is it, let me see here.
If she has it, then I understand it, but yes, sir.
It was, no, somebody must have it. Stephanie?
Okay. Yes, that's correct.
Yeah. So is that a yes from you, Mr. North? You would
Yes.
like this transcribed?
Yes, sir.
Okay.
Okay, well, we will get that order out to you all. Thank y'all.
Thank you, Judge. Have a great
Thank
day.
you.
All
Thank you,
right.
Your Honor.
Pleasure.
Good to
Thank you.
see you both.
All
Ciao.
right, thank you. You
Take care,
too.
Dean.
All right, yes, sir. Bye-bye. See you.
Miss Val, you need me for anything?
No, I don't think so.
I figured it out, Miss Val, so stuff is gonna start coming your way.
Okay.
All right, bye.